All right. Hey, everybody. This is Benji Rosenzweig and Ben Hubert from Colliers, Detroit. And we thought that we would have a conversation with our good friend, Gary Kravitz, who's an attorney that we've done a lot of business with and we refer a lot of clients to talk about force majeure and what that looks like today with COVID-19. There's a lot of confusion, a lot of questions. We're spending a lot of time answering questions for our clients and giving them information so that they can stay current and, as I don't want to say unconcerned because they are concerned, but rather than making it up, we figured we'd talk to Gary and get some good answers. Before we get into the questions, Gary, do you want to introduce yourself?
Yeah, good morning, guys. Thanks for having me on. My name is Gary Kravitz. I'm an attorney with Maddin Hauser. I specialize in real estate and corporate law. I do an extensive amount of leasing work and also purchase and sale transactions. I've been an attorney for over 20 years, and I've had the pleasure of working with Ben and Benji on several of their transactions and getting their work and their deals to close.
Thanks, Gary.
Thank you, Gary. So let's start off with the non-attorneys, layman's language. What is force majeure?
So force majeure is one of those fun legal Latin terms. Technically, it means superior force, but in layman's terms, what it means is an unforeseen event that excuses a party's performance because they cannot perform their obligations under a contract. So it has to be something that's unforeseen, unexpected, and gets in the way of the ability of a party to perform under the agreement in question.
So the first basic question that everybody's going to ask is, does COVID-19 fall under this category?
Well, and that's a very interesting question, and you're going to love this response. It's a classic lawyer response. It depends. So the answer is, it depends on a couple of factors. Number one, does the contract that you're looking at have a force majeure provision? If the contract that you are looking at does not have a force majeure provision, then force majeure is not applicable, and you're going to have to look at other legal principles to try to defend yourself against performance under the contract. If you do have a force majeure provision, then a lot depends on the language of that contract and the language of that force majeure provision. Part of it, I was looking back at one of my leases, and I just have it over here. One of my leases that I have a force majeure provision in included things such as a pandemic and governmental closures due to various conditions. So in that provision, where it included pandemic, it included governmental forced closures as a force majeure provision, then yes, something like COVID-19 would be covered. However, if your force majeure provision doesn't include items like pandemic and doesn't include such items as forced closure by the state for various reasons, then you may be out of luck. My provision that I include in leases often also includes acts of God. Some people might say, is an act of God force majeure? Well, it depends if it's in the contract. If it's in the contract, then you might be able to argue that COVID-19 is an act of God, and therefore you get that coverage. So the last thing I wanted to note was often some force majeure provisions have a catch-all clause. And that catch-all clause may say, any unforeseen event that is beyond the control of the party. That's a large catch-all provision that may include something like COVID-19. Bottom line, you've got to look at the specific language of your contract, your lease, and see if you fall under that category.
So a lot of detail in that answer. I got a couple of follow-up questions. So I think you clarified it. I just want to clarify one more time. So act of God and force majeure are not the same thing, although they are often in the same sentence. And then the second question is, does pandemics or does any of these events have to be specifically spelled out in the force majeure clause, or if that catch-all language, any unforeseen circumstances? So if somebody has a force majeure clause that's just one line, is it not a sufficient force majeure clause, or how does that work?
So to answer your first question, I would say acts of God are a subset of force majeure. Some force majeure provisions start off saying the party is excused for various reasons, such as acts of God, and then it goes on to a laundry list. So it's a subset. In answer to your second question, force majeure clauses are interpreted strictly by courts. So it really depends on the language of your contract. If it doesn't have the words pandemic in it, if it doesn't have the words forced governmental closures, then you are relying on potential other clauses. If it has a catch-all clause, some do, some don't, then you're trying to interpret that language. If it has acts of God, then you have an argument that an act of God and pandemic are similar, and it should be covered. But those are those gray areas that you may not get coverage, you may get coverage. And the last thing I want to note is sometimes, particularly in lease agreements, the force majeure clause may be one-sided. It may only apply to the landlord. And then a tenant who's trying to use force majeure to defend itself, they may be out of luck. The second thing I want to point out is many times in lease agreements, and because we all deal with leases rather frequently, a lot of lease agreements have a clause that says this force majeure clause will apply to both parties, but it won't apply for failure to pay rent. So it could apply if the tenant hasn't done repairs. It could apply if the tenant hasn't cleaned up the space appropriately. But if the tenant looks to use that provision to get out of rent payments, if it has that clause that says this does not apply to failure to pay rent, then they're out of luck in that particular lease.
Interesting.
Gary, how does it play in when you have a mandating closure if there's no force majeure?
Ben, you froze up for a second. Can you repeat the question?
Yeah, if there's no force majeure, how does a I don't know if my connection's unstable, but if there's no government, if there's a governor mandating closure, how does that affect a lease that does not have force majeure?
In that instance, the tenant may be stuck because the obligation to pay rent is often independent of all of the other provisions in the lease. And in that instant, the tenant may need to either A, buckle down and pay the rent, or B, what I've been recommending to a lot of tenants is you need to start a dialogue with your landlord. You need to call your landlord and say, look, here are the circumstances that I am in, and we don't have a force majeure provision, but you realize I can't open, I'm prohibited from opening, and if you force me to pay rent, I may not be able to continue to operate my business. I may go bankrupt. And it would be in everybody's best interest to give me either a rent holiday, a rent deferment, a rent decrease. These are all options available, but it pays to talk to your landlord and say, this is the current situation. And I know for a fact that there's landlords out there that, particularly in Detroit, have given rent holidays for a couple of months. And in other instances, certain landlords have agreed, we're gonna move that rent obligation to a later date. They're not deferring it, they're not eliminating it, but they're moving it or reallocating it to later in the lease.
And I think what you're saying there is, if you've got 40 months left on your lease, a landlord says, we're going to pause the rent payments for 3 months, but now at the end of that 3 months, you still have 40 months of payments left, not 37 months of payments left.
Yeah, correct.
Right.
Correct. It's all different types of negotiations, and the other thing that I wanted to point out is, with a force majeure, let's say you do have a force majeure provision in your lease, don't just sit on it. You need to tell the landlord that you believe that you are in a force majeure event and that you are not paying rent, if you're allowed to, not paying rent or not performing certain obligations because you believe you are in a force majeure event.
So you just touched on that question, which is, today is March 27th. We're a couple of weeks into this COVID-19 situation. When's the right time to start, looking at your lease to see if it has force majeure and what the language looks like? And when's the right time to start talking to your landlord about it?
Well, my response to that would be immediately. You need to look at your lease right now, because I think the earlier you have that dialogue, the better off you will be. A lot of my clients who, let's say I've got a few clients who run restaurants, they are struggling. They had to fire employees or lay them off. They can't operate as they normally do. They've seen reductions in their business of 60, 70, 80%. And I have told them, you need to get on the phone with your landlord and you need to talk to that landlord now about the situation. It's also important because, and this is sort of jumping back to a prior discussion, but a lot of force majeure clauses do have time periods. The force majeure provision may say, if you are experiencing force majeure, you need to contact the other party within X number of days of that force majeure event. And if you don't, then you lose the right to claim force majeure. So you need to look at those leases, those contracts immediately to make sure that you don't lose your rights. And if you have rights, you assert them, and to see if your landlord's open to deferring rent obligations so that you can alleviate some of the stress that you're experiencing.
So let's get macro for a second, because
Sure.
You just touched on something that I hadn't thought of. So what is the force majeure event? Is it the first COVID case in Michigan? Is it when Governor Whitmer announced the stay at home? Is it the first death in Michigan? Is it when the business started hurting? Is it when they had to lay off employees? When is the force majeure event?
And that a lot depends, again, on the language of the lease. If you've got, or contract, if you've got a provision that says pandemic, then it may be when, the World Health Organization said we have a pandemic,
right?
A worldwide pandemic. The instant that your business starts to suffer because of the worldwide pandemic, then you've got a potential force majeure event. But if your lease or other contract only says forced governmental closure, then that's the trigger event. Again, and I hate to keep on beating the same drum, but a lot depends on the specific language of the contract you're looking at.
Hey, Gary, real quick, Gary, what happens if you don't have a force majeure in your contract and the landlord is not willing to work with you? What would be your advice to that tenant?
Well, you've got to, and this touches on a couple of issues. There are some common law defenses that might be available under general contracts. Under leases, it's a little bit more difficult, but if we're talking just general contract law, there's two common law principles called frustration of purpose of the contract and impossibility. Those are two defenses against performing your obligations under a contract. Under a lease, as I've said before, it's more difficult because the obligation to pay rent is often independent of any other covenant under the lease. The one thing that I have been advising some of my clients is that they need to look at, hopefully they have it, their business interruption insurance. Because if they have a policy of business interruption insurance, it may, in fact, cover this type of situation. You've got to look at the contract, got to look at the insurance provisions, but you may be covered because at this point, with forced governmental closure, you may be able to say, my business is interrupted, I can't operate, and therefore the insurance provision should cover me. And that's an important other angle to look at. Contact your insurance provider.
That's a great point.
Can you give us a couple of examples in our careers of force majeure? I mean, the obvious one is 9/11. Or any other times that you've dealt with this?
Well, force majeure could occur with tornado. The work shortage or strike or unavailability of materials. There are certain events like where you've got a shortage of building materials and you can't, let's say the tenant is in the build out phase and the tenant either A, can't get their permits, can't get building materials for something completely out of their control. If the lease says, those items are covered, then that would be a force majeure event. And interestingly enough, if the tenant is in the build out phase, they haven't yet reached rent payment phase, then a force majeure clause may really help them because they may be able to say, look, I can't build, and therefore my obligation to start paying rent should be deferred.
Right. We have a couple of those situations right now we have to deal with. Is there anything else that you want to touch on or talk about? We've been on this for about 15 minutes, so we want to wrap it up. Are there any other items that you think that we should talk about before we go?
The only other thing, and I know that this was a question that, let's flip things on their head for a second. We've been talking a lot about tenants, but one thing that we should also observe is talking about our landlords. And, what do they do? Because what we've got is tenants asking for breaks on leases, but the landlords have obligations, and they have obligations to their lenders. And So a lot of questions that I've been getting from my clients who are landlords is, what can I do? And what I've told them is, unfortunately, a lot of loans out there, or I should say the majority of loans out there, don't have any force majeure defense. You can't get out of paying a loan obligation. In fact, most loan obligations have clauses that are opposite. They say if the lender feels insecure, the lender can declare a default.
Right.
So what I've been telling my landlords, call your lender. See if your lender can give you a deferment of payment. Because the last thing that the lender wants to do is take back property.
We've been speaking to a lot of our friends and colleagues in different, both Colliers offices and non-Colliers offices around the country, just seeing what's going on in different places and talking about best practices and navigating these awkward, waters. And what we're seeing is that banks don't really want thousands of properties back today. Unlike 2008, when the banks just said, we're foreclosing on everything. They don't want them back. They want to figure it out. For the most part, the banks want to work with the landlords. But I think you gave the best advice there, which is communication. Talk to your lender, talk to your landlord, talk to your attorney, talk to your broker. Don't stick your head in the sand and try to figure it out later. I think the best communication early on is probably the best way to go about this.
Right. I completely agree. And I think, as I said before, the earlier you do this, the better off you will be. Everybody knows what the situation is, and this is going to be a domino effect.
Right.
Tenants can't pay landlords, landlords can't pay their lenders, and it'll cascade on from there. So the communication, the discussion has to start now.
Right.
Let's just hope this is a temporary event and not a permanent event. Like,
right.
There will be some closures that'll be more permanent for tenants to just have to close the doors, but hopefully this will be something that we can get through, and the tenants will come back, and and it'll just be a temporary situation. It's the best that we can hope for.
Yeah, I agree.
Good. All right. Well, Gary, we appreciate you spending some time with us this morning, and we're gonna post this with contact information for you so that people can follow up with you if they have any questions. And we hope you and your family stay safe and healthy. And looking forward to breaking bread with you and shaking your hand in a few months when we're all comfortable shaking hands again.
Same here, and hope you and your families are doing well. And we'll see you in person in hopefully only a few weeks, but we'll see. We'll see how it goes.
Thanks, Gary.
Thanks.
Take care. Bye-bye.
Bye.